hello all, welcome to yet another live session of Narayana IAS Academy. So this is Sureka Bhaskar presenting to you the daily news analysis, and of course for our discussion today we've picked up the top most important articles from both the Hindu as well as the Indian Express that are equally important and relevant for your preliminary examination 2025, okay, as well as for your mains examination. That is basically your UPSC civil service examination. So now without much delay, let us actually kickstart our day with our daily motivation. So what is written behind me? So here it says, work hard in silence and let success make the noise. So this is a very important thing that we need to imbibe and take care of, because success in itself or naturally will attract recognition. So what do we do is that we have to focus on our goals without seeking any kind of attention or not boasting about our plan. So success will ultimately actually seek recognition. So this is what the article actually says. So while you're preparing for the UPSC examination, without making much noise that I am the next district collector, I am the IAS officer, instead of stating such things, you just have to focus on your preparation in silence, and finally the rank list will actually make the noise. Okay, so now let us actually move forward in order to look at the initiatives that Narayana IAS Academy has actually brought forward in order to ease your preparation for this UPSC examination. So we have actually come up with a 1-year prelims cum mains integrated course for the 2026 examination and a 2-year prelims cum mains integrated course for the 2027 examination. Okay, so the entire time duration of the course will be around 1000 plus hours, where 800 hours are exclusively given for your general studies as well as your CSAT, and the remaining 200 hours are exclusively dedicated for your current affairs. So this particular class will be taken by our expert faculty who have appeared till the interview stage of the examination, and along with the general material that will be provided for you, for your preparation, we will also give you a strategic micro schedule. That is nothing but it is a detailed daily plan giving you which topic to be covered under which theme and sub theme, so that you're not lost in the vast syllabus that the UPSC actually gives. And in order to give you your performance analysis, we also have the test series, that is a Saksham test series, where you will actually be taking up the test and we will be understanding on what are the mistakes that you have actually committed based on the feedback that we actually give you. Okay, so now without delay, let us actually move into and dive into these particular topics that we've picked up for today's discussion. So the first article for the day has been picked up from page number 1 of the Hindu. Free speech is an integral part of healthy and a civilized society, says the Supreme Court. So recently there has been an FIR that was filed by the local police of a particular state against a Congress MP, okay, for the poetry that he had actually posted on social media. So for that, the Supreme Court had, stated that what do you say, free speech has to be an integral part of a healthy and a civilized society, and it cannot be used, or you cannot say that a person while posting a poetry, it doesn't mean that he is actually violative of article 19, that is free speech and expression, that is guaranteed to the citizens under the Indian Constitution. Okay, so here we will be discussing about the concept of free speech and expression. Okay, whether it is absolute or not. So basically article 19 clause 1 and 19 clause 2 will be discussed, and this will be a part of our mains discussion. Okay, now moving forward, the second article talks about, that is, it's been taken from page number 3 of the Hindu, that is, Indian courts have around 1.45 lakh contempt cases pending. So here we need to understand what do you first of all mean by the contempt of court. Okay, so whether the constitution itself defines what you mean by the contempt of court, and what are the definitions of the different types, that is the criminal contempt and the civil contempt, or under which committee the legislation was actually formulated in order to regulate this particular contempt of court, whether it is a part of fundamental rights or not, or whether it is a part of reasonable restrictions guaranteed by the constitution or not, all that we will be looking into. So with respect to contempt of court, after understanding the concept, we will know what are the number of cases that are pending with the Supreme Court as well as the High Court with respect to that of the contempt of court case backlogs. Okay, so here we will be talking about what do you mean by contempt of court. So this is going to be a prelims discussion. Moving forward, the third article has been picked up from page number 1 of the Hindu. Massive quake kills at least 144 in Myanmar and 8 in Thailand. Okay, so junta seeks foreign help. So this particular article, as all of you would have heard about, so recently a 7.7 magnitude of earthquake had actually jolted Myanmar, okay, and the surrounding areas of Thailand. This has actually caused a lot of destruction to life as well as property. So here we will be understanding the concept of what do you mean by earthquake and what are the associated terms, like what do you mean by focus, what do you mean by epicenter, what do you mean by faulting, okay. And we'll also look into what is the fault that was actually the causative or the driving factor behind this particular earthquake, okay. So here we will be understanding the different types of faults, the concept of faulting, etc. So this of course is going to be your prelims article again. So moving forward, the last article for the day has been picked up from page number 3 of the Hindu again. Center signs around 63,000 crore deal, okay, with respect to that of HAL. That is, this talks about the recent defense deal that has been signed between the Ministry of Defense, that is the Government of India, as well as Hindustan Aeronautics Limited, with respect to that of acquisition or procurement of indigenous light combat helicopters, that is LCH, okay. So now after discussing these 4 articles, we will actually be solving the MCQs that have been discussed, the MCQs for the topics that have been discussed yesterday. Following that, we will be solving one mains approach question as well as the MCQs will be posted which will be related to these particular topics, okay. So now let us quickly start with our discussion. So the first topic for the day has been picked up, from the first page itself. Free speech is an integral part of the healthy and a civilized society. Okay. So here the Supreme Court recently quashed an FIR that had actually been filed by the local police. So we will actually see against a Congress MP, which actually stated that it was not abrupt, okay. So this is what the police had actually said and had taken the action, but such an FIR which was filed was quashed by the Supreme Court. So here freedom of speech and expression becomes very, very important, and as such it's a part of fundamental rights. So here we can actually map it to mains, that is GS paper 2, features of the Indian Constitution and significant provisions and basic structure, okay. So now let us actually move forward and see what has been the type of question that UPSC has asked in one of the previous years. So in 2014, they had asked a question on what do you understand by the concept of freedom of speech and expression? Does it actually cover hate speech also? And why do the films in India stand on a slightly different plane from other forms of expression discussed? So this is the kind of question that UPSC had asked. So you know that freedom of speech and expression, not only that, all the other rights that are actually enshrined in the Constitution of India becomes very, very important, specifically the fundamental rights. So what is the context? The Supreme Court had emphasized that the freedom of speech and expression is fundamental in a democracy, okay, and it cannot be suppressed. So just because a person posts a poetry of his will or whichever he has actually penned down, those are very flimsy grounds on which you can take action against that person, right? Because that person has the fundamental right of freedom of speech and expression. So this is what the Supreme Court had actually said. Now let us see more on this particular news. So there was an FIR which was actually filed by the Gujarat police on the Congress MP for the poem that he had actually posted on the social media, okay. So the FIR actually alleged that this poem could actually be a ground for inciting some kind of religious disharmony or communal violence, okay. But the court actually disagreed with the police, and it actually said that this was a clear abuse of process of law, and it also ruled that the freedom of speech is a fundamental right under Article 19 clause 1 subclause A, and this particular freedom of speech and expression is definitely essential for a functioning, that is what to say, for an efficient functioning of the democracy, and it cannot be curbed on any kind of flimsy grounds like this, especially in matters of artistic expression, okay, whether it is a painting or whether it is a poetry or whether it is any of your soft skills, okay. So this is what the Supreme Court had actually told. Now let's move forward and understand about the freedom of speech and expression. So what is this particular freedom of speech and expression? If you see generally, this is nothing but it is a bedrock of every democratic society, because if there is an authoritarian rule, what happens is that there will be a situation where the citizens are not able to express whatever they feel against the functioning of the government in an efficient manner, okay. But in a democracy, what happens is that this particular freedom of expression and speech actually forms the bedrock in such countries, and it is in fact called as the mother of all the freedoms, because it empowers the individuals in order to express or voice their opinion or thoughts, okay, as well as access the information freely. That is why RTI was also stated by the court, it is actually form of the fundamental right, it forms a part of the freedom of speech and expression, that is right to information. So in the Indian constitution specifically, this particular freedom of speech and expression forms a part of fundamental right under article 19 clause 1 clause A, which states that all the citizens shall have this particular freedom, okay. And globally, if you see, it forms under or it falls under article 19 of the Declaration of Human Rights, okay. So universal declaration of human rights. So under Universal Declaration of Human Rights, this is globally recognized, and also under International Covenant on Civil as well as Political Rights, that is ICCPR, okay. So this is what is the freedom of speech and expression. Now moving forward, let us see what are the elements of for this particular right to freedom of speech and expression. First one, this is actually exclusively given to the citizens of India, and it does not apply to the foreign nationals. Very, very important. So you need to know what are all the list of fundamental rights that are available to the citizens and which are not available to the foreign nationals, okay. So here it is only available to the Indian citizens, and the foreign nationals do not enjoy this right, and it is broader in scope, where one can actually express their views and opinions, and also through different mediums it can be expressed, whether you are writing or whether you are printing, okay, or through word of mouth, picture, movie, etc., okay. And this is however not absolute in India, so it is subjected to certain reasonable restrictions. We will see what are reasonable restrictions that are mentioned in article 19 subclause 2, okay. So here it's the state's duty, that is if the state fails to guarantee this particular right, then it is considered to be violation of article 19 clause 1 subclause A, where what happened, the citizens can move to the court. Now, let us actually move forward and see what are the key components of this particular right to freedom of speech and expression under Article 19 clause 1 subclause A. First is freedom of the freedom of the press, okay. So this is very, very important. Next one, they have the freedom to broadcast, okay, that is provide information to the individuals about the functioning of the government. So freedom of the press, freedom to broadcast, right to information, of course, is a part of right to freedom of speech and expression. Very, very important. So you need to here know about the RTI Act of 2005 and its respective amendments, if any, okay. Then the freedom of commercial speech, and also it includes the right to criticize and right to expression beyond the national boundaries, and also right not to speak or right to be silent, right to silence. So all these are key components of this particular right. Now moving forward, let us see if this particular freedom is actually absolute. Absolute means you can say anything through whichever medium you want, whether by artistic means or through movies or through speech or broadcasting, etc. No, this particular article is not absolute. That means there are certain reasonable restrictions that are enshrined in the constitution under article 19 clause 2. So what are these reasonable restrictions? That is, if any speech that is actually inciting or posing a threat to the public peace, then that expression is not allowed. Okay, so the reasonable restriction here is public order. The second one, in case if the speech actually threatens the security of the state, such as it can actually be the rebellion or it can be war, insurrection, etc. So this is under security of the state. The next one, friendly relations with foreign states. That is, any expression that can harm the India's diplomatic ties, this can also be restricted, and this particular provision was actually added through the First Amendment Act of 1951. So there are certain provisions that were added under the First Amendment Act of 1951, you need to know. So first one is friendly relations with the foreign states. Next one, decency and morality. That is, any content or the expression that is actually very vulgar, that is offensive or it is obscene, then that can actually be restricted under section 292 to 294 of the Indian Penal Code. Now it has become Bharatiya Nyaya Sanhita, that is your BNS. Okay, so these are the reasonable restrictions for against your freedom of speech. The next one, if a person or if any newspaper or broadcasting, so they actually telecast something which is actually interfering with that of the administration of justice, or which is very offensive to the judicial proceedings or the judicial independence or the authority, then it is actually called as contempt of court, and such an act is not allowed. So this is also another reasonable restriction. Next one is defamation, that is harming the fame of a particular person through false statements or false information, which is actually defined under sections 499 and 500 of again the IPC. This is nothing but the Bharatiya Nyaya Sanhita. And also incitement to an offense, that is, you incite or you provoke a person to actually commit crimes or commit suicides, that is also a criminal offense, and this also got. The first one is what? Friendly relation with the foreign nations, that was also added by the First Amendment. Here, incitement to an offense, this was also added through the First Amendment Act of 1951. Next one, if any expression actually threatens the sovereignty and the integrity of India, then that is also curbed or it is curtailed, and this provision was actually added through the 16th Constitutional Amendment Act of 1963. So this is what it is. Okay. Now let us actually move forward. What are the important cases? So far, what did we see? We actually saw why recently the Supreme Court reinstated the importance of this particular right to freedom of speech, speech and expression. Then we looked into what is this particular freedom of speech and expression that is enshrined in the Constitution, and then we actually saw what are the key components, whether it is exclusively given to the citizens of India or it is applicable to the foreign nationals also. This is what we saw. And next, moving on, we actually saw what are all the reasonable restrictions. That is, we know this particular fundamental right is not absolute and it is subjected to reasonable restrictions, that is security, the sovereignty of India, and then the integrity of India. So all that has actually been mentioned. Now moving on, we will see what are all certain judicial pronouncements, that is what did the Supreme Court have to say on this particular right. So first one, in Romesh Thapar versus the state of Madras in 1950, the Supreme Court had actually stated that freedom of press, this is extremely essential for a democracy, and also for the political decisions to actually take place, for all that, it is actually essential for functioning of a democratic type of a government. Okay, because India is a land of multiple political parties, and it is a diverse country, right? So in such a place, what happens, this freedom of speech or press becomes very important. Next one, in Bijo Emmanuel versus state of Kerala in 1986, This, the Supreme Court actually said that you cannot expel any of the students for refusing to sing the national anthem on basis of their religious grounds, and this is, if you actually restrict or expel them, this will be violative of Article 19 clause 1 as well as the right to freedom of religion, that is Article 25 clause 1. Now moving towards Odyssey Communications Private Limited versus Lok Vidyan Sanghatan. This case was in 1988, where the Supreme Court said that the right to exhibit films in Doordarshan is actually allowed, okay, and it is a part of freedom of expression under 19 clause 1 clause 8. That is, anyone can actually put up a film in Doordarshan and it can be restricted only on the grounds of Article 19 clause 2 is what this particular judgment actually said. Moving on, S. Rangarajan versus P. Jagjeevan Ram, 1989. Here the Supreme Court said restrictions must be based on necessity under Article 19 clause 2 and not just because of the political whims and fancies. So this is what it said. Next one, Union of India versus Association for Democratic Reforms, okay, that is the ADR 2002. It actually said that freedom of speech, it actually includes the right to receive and impart information, and this also includes the right to know about the political candidate. So you can actually have the right to know about who is contesting the elections, whom you're going to vote, so that you make an informed decision. So these are the important cases that were relevant. Next, does freedom of speech and expression cover hate speech? So very, very important. So what do you mean by hate speech first of all? So it is any kind of expression where it is actually seen, if any kind of expression is inciting some kind of violence or communal disharmony or any kind of hatred against individuals or particular group based on attributes such as, it can be religion, it can be ethnicity, it can be caste or language or gender, then that is called as hate speech. So the Supreme Court again in 2014 at this Pravasi Bhalai Sangatan versus the Union of India. Here, what did they say? This hate speech actually undermines the dignity of the individuals and hence can be restricted as one of the reasonable restrictions under Article 19 clause 2. And also in Shreya Singhal versus Union of India 2015, this actually struck down section 66A of the IT Act, okay. So, the 66A of the IT Act was actually a very, controversial legal provision. So, this actually said, or it criminalized sending messages, okay. So, it criminalized sending offensive messages through mail, social media or messaging platforms. But the Supreme Court actually clearly said that speech, only the speech, remember, only speech that leads to incitement or has a tendency to create the public disorder can be restricted, okay. So this is also, the hate speech, which is a part of reasonable restriction. Now let us see what is the relation that the right to freedom of speech and expression has with that of the right to information, okay. So this right to information is definitely considered to be a part of fundamental right to freedom of speech and expression under Article 19 of the Constitution, and the Supreme Court has been consistently upholding that right to free speech is not just limited to expressing one's views, but also not just because I'm talking and I'm expressing my emotions through different mediums or my dissent through different mediums like writing a poetry or broadcasting something, but also I have the right to know, to receive as well as access information. That is, if I want to know about what is the amount of asset that this particular candidate who's contesting election in my constituency has, if I want to know that, then I have the right to know it, okay. So that is what is the link between the right to information as well as the right to freedom of speech, okay. Now let's move forward. In the state of UP versus Raj Narayan in 1975, the court actually ruled that people definitely have a right, okay. That is, they have a right to know every public act and also details about the public functionaries. Very, very important, and such a right is derived from this particular freedom of speech only. And also, if you see the RTI Act of 2005, it gives statutory shape to this particular constitutional principle. Okay, now let us actually move forward. So now we've actually come to the end of a very elaborate discussion about what is the importance of right to freedom of speech and expression. So, speech and expression. What is the importance of speech and expression, and what does the constitution actually have to say on these? Now, let us move forward and understand the second article. Indian courts actually have around 1.45 lakh contempt pending cases. Okay, so here what we have to understand is what do you mean by contempt of court. This is of course a part of the Indian judiciary, which is a part of the Supreme Court, the High Court, etc. And this is an important part of polity under prelims examination, and for the mains examination it falls under GS paper 2, structure, organization and functioning of the executive and the judiciary. Okay, so now let us quickly move forward and see what kind of questions have been asked in the previous year with respect to judiciary. Okay, so with respect to Indian judiciary, consider the following statements. This has been a question of 2021 prelims examination. So here, any retired judge of the Supreme Court, when you take judiciary, whether it is the Supreme Court or the High Court, first you need to know when can a citizen move a court. Okay, whether it is actually violative, if anything happens which is violative of the fundamental rights, whether then they can move directly to the Supreme Court, or whether the High Court actually has also has the power to hear it or not, that you need to know. And under Supreme Court as an organization, when was the concept of the Supreme Court or the apex court of India was actually established, to which of the charter acts? That is what you need to know. Moving forward, what is the composition or the constitution of the Supreme Court? What do you mean by the collegium system? Whether we actually have NJAC, and what was this NJAC? What does it entail? Does it actually have the government representation more, etc. is what you need to know when judiciary actually comes up. Okay, so this particular article is specifically talking about an aspect called as contempt of court, because there have been an increase in the number of the backlog of contempt of court cases. That is, pendency of these cases are increasing in the Indian judiciary is what this article is talking about. So, if you see the exact figures, so these figures have actually been taken from the National Judicial Data Grid. So, this is nothing but it is a database which actually talks about the total number of cases, the pendency of the cases that have been heard, etc. And this actually deals with the number of cases in the high courts and not the Supreme Court. So, according to this particular NJDG, what happens is that there have been, that is, as of 2025, there are around 1,43,000 and odd cases of contempt of court that are pending in the high courts. And if you see the status of cases which are in the Supreme Court, it numbers around 1,852 pending cases. And totally, if you see in the judiciary, there are around 1.45 lakh contempt of court cases that are pending. Now, it's important for us to understand what do you mean by the contempt of court. This is nothing but in order to protect the administration of justice as well as the independence of the courts. What happens, this is actually a legal mechanism in order to protect the authority of the judiciary in India, whether it is the Supreme Court or whether it is the High Court. Okay, so it is a legal mechanism to protect the dignity of the judicial institutions from undue discrimination, okay, or undue criticism or interference. Nobody can criticize just like that the judiciary. So, judiciary is actually an apex institution, right? So, here nobody can actually do an undue criticism, okay? So, this ensures that the judiciary can function independently. At the same time, judiciary can also punish the person who has actually done, that is, who has undermined its authority under contempt of court. Now, let us see the constitutional basis. Does judiciary prescribe the punishments or make laws for these contempt cases? No, very, very important. It has also been in the examination. The parliament is the only body which actually makes laws on the contempt of court. And if you see the constitutional provisions, we have Article 129 and 215, which actually gives the Supreme Court and the High Court the power to punish the contempt of court, recognizing them. That is, these actually become the court of record. That is, these bodies, that is Supreme Court and the High Court. Next one, the freedom of speech restriction. You also know, right, Article 19 clause 2, which actually lays reasonable restriction, has contempt of court as one of the reasonable restriction. So this is actually listed it is listed as one of the reasonable restrictions under fundamental rights. Next one, there was this Contempt of Court Act in 1971. Very, very important. So there was a committee, okay, that is the H.N. Sanyal committee. So there was a report which was actually given or submitted in 1971, according to which what happened? The Contempt of the Court Act of 1971 was passed. So this particular act provides a clear statutory framework of the contempt of court, defining it, the types, as well as what kind of penalties should be given to the person who commits it. Okay, so again, the types, that is the criminal contempt of court or the civil contempt, these are all defined under this particular Contempt of Courts Act of 1971, and it is not defined by the Constitution of India. Very, very important fact again. Next one, if we see the punishment for the contempt, again the punishment is given under the Contempt of Courts Act of 1971, which gives imprisonment up to a period of 6 months or a fine up to rupees 2000 or more. And there has been an amendment which was made to this particular act in 2006, which introduced the truth and good faith as defense. Okay, that is, punishments can be given only if what happened, the administration of justice is actually affected. So this is what it is. Next one, what is not considered a contempt? Very, very important. If you are giving any kind of fair as well as an accurate reporting of the judicial proceedings, or if you are giving a very rational and a fair criticisms of a judicial order, once a case is heard and disposed of, then it is not considered to be a contempt. So whenever it is fair and rational, that is when it is considered, it is not considered a contempt. Next one, what are the different types of contempts? Of course, this is again under section 2A of the Contempt of the Courts Act, that is 1971, not defined by the Constitution. So this actually mentions two kinds of contempt, that is civil as well as the criminal. So civil is nothing but willfully if you are disobeying any kind of order that has been given by the court, or any kind of decree, any kind of judgment that is given by the court, or if you are breaching an undertaking which is given to the court, then it is called as civil contempt. What do you mean by criminal contempt? That is, if you are actually publishing anything. So any kind of publication, whether you write about it, whether you speak about it, or visual, that scandalizes the court, or it lowers the authority of the court, or it creates prejudice about the judicial proceedings, or it obstructs the administration of justice, then it is called as the criminal contempt. Okay, so this is called as the contempt of court. So here we have actually dealt with two articles so far. So one is freedom of speech and expression, 19 clause 1, and this contempt of court was also a part of the reasonable restrictions that is given under Article 19 clause 2 of the Constitution. Okay, now let us move forward. Massive quake kills at least 144 in Myanmar and 8 in Thailand. Junta seeks foreign help. Okay, so it's a very sad thing that such a bigger earthquake of around 7.7 magnitude has actually hit Myanmar. Okay, so Myanmar as well as Thailand earthquake. So this becomes important for prelims as well as the GS paper 3 mains, disaster and disaster management, and also important geophysical phenomena, where you have earthquake, where you have landslides, and here cloudbursts. You can also have tsunami, etc. So all these can be considered as important geophysical phenomena. So now let us move forward and see the PYQ in 2016. It has asked about this Himalayan region and why it is extremely prone to landslides. So discuss the causes and you have to suggest suitable measures of mitigation. So very important question. So now let's move forward and understand why this particular earthquake was in the news. So a powerful and a very catastrophic 7.7 magnitude earthquake had actually struck central Myanmar near Sagaing. Okay, so this is actually a fault where the Indian plate and the Eurasian plate slide past each other. Okay, so Indian plate and the Eurasian plate actually slide past each other. Do you understand? So here there has been an earthquake. This actually struck this particular fault region, that is the Sagaing region, which killed over around 150 people. A lot of people were actually injured and a lot of property damage was actually been done. So now let's move forward to understand what do you mean by earthquake. Earthquake is nothing but the trembling or the shaking of the earth's surface. So this is caused by the seismic waves, that is what you call as the P waves, as well as the S waves, the love waves, the Rayleigh waves, etc. Right? So these are the seismic waves that cause earthquake. And why are these waves caused? Due to the sudden movement or the trembling, where there is extensive sudden release of energy in the earth's crust. Okay, so this is the earth, and here what happens, there is a point which is called as what, the focus inside or below the inside the earth's crust, where the earthquake actually originates, and it gets transferred to the ground, and the point directly or vertically above this particular focus is called as the epicenter. Do you understand? So here if you see, this is the focus region where the earthquake actually begins. The tremors are actually passed and it is sent towards the the surface of the earth, and the point directly above this particular focus is called as the epicenter. So directly above the focus on the ground. Okay, so this is what it is. The next one is the fault. This is nothing but it is a weak point. So a weak point in the tectonic plate where the pressure from within the crust is actually released. So this is actually considered to be a fault. Okay, so there are different types of faults. We'll actually be seeing it. They are the normal faults, the reverse faults, okay, as well as the strike faults. Let us actually see what are the different types of faults. So if we see earthquakes, I told you what is the focus. This is nothing but the point inside the earth's crust where the earthquake originates. Okay, so if this is the earth, the crust of the earth, if this is actually the focus, then the earthquake, the tremors are actually passed on to the surface. In case if the focus is shallower, if it is nearer to the ground, then the catastrophe it actually causes will be larger. So the shallower focus leads to greater surface damage. Okay, this is what it says. Next one, epicenter, point on the earth's surface directly above the focus, which we already saw, which is actually used to what? Usually it is the area which actually gets the maximum impact. Okay, so this is actually called as the epicenter. Next one, what is the magnitude? How much of energy is actually released at the source? So this is measured using the Richter scale or the moment magnitude scale. Okay, and this is actually logarithmic. Next one, the intensity. What do you mean by intensity of the earthquake? It measures the amount of damage that is caused at specific locations, and this is actually calculated or measured using the modified Mercalli intensity scale. Very important question again asked in the exam. Okay, now moving forward, let us see what is faulting. This is nothing but it is the displacement of the earth's crust. What is it? It is the displacement of the earth's crust due to the tectonic forces, and this actually happens when the amount of stress this exceeds the strength of the rock. So there are different types of faults. One is the normal fault. Okay, so here what happens, there are two kinds of walls. One is the foot wall, and the next one is the hanging wall. Okay, so the normal fault, when does that happen? When, see, these are two plates. Okay, so these are the hanging wall. For example, this is the hanging wall and this is actually the foot wall. So when there is a divergent plate boundaries, okay, divergent is moving away from each other. When there is actually moving away, what happens is that the hanging wall moves down. Okay, so this is actually the hanging wall moving down and the foot wall is moving up. That is called as the what to say, the normal fault, and this actually happens by extension, that is nothing but the divergent plate boundaries. So hanging wall moves down and the foot wall moves up. Whereas if you see the reverse or the thrust fault, it is due to convergence. Okay, converging boundaries, where the hanging wall moves up. Because of convergence, hanging wall moves up and the foot wall actually moves down, and this is called this is by compression, and that is called as the thrust fault or the reverse fault. Whereas the strike fault or the strike slip fault is nothing but it is like a transform boundary where the plates actually move across each other. Okay, so the horizontal movement where the plates slide laterally. So here it is the transform boundaries, and the perfect example of this is the Sagaing fault, because of which the Myanmar earthquake had actually taken place. Now we'll see a pictorial representation. This is a normal fault where there is actually convergence. It is moving away from each other, where the hanging wall goes down and the foot wall is gone up, right? And here it is actually the reverse fault or the thrust fault. This is the thrust fault, okay, where there is actually what, compression that is taking place. So the hanging wall goes up and the foot wall goes down. And next one is the strike slip fault, where there is actually lateral movement of both the plates. So there is actually movement like this. So this is like a transform boundary. Okay, so this is actually a perfect example of the Sagaing fault. Now let us actually move forward and see. Again, we know, right, this cause of this particular earthquake was the strike slip faulting, along the Sagaing Fault, which is nothing but one of Southeast Asia's most prominent seismic zones. You know, seismic zones where earthquakes are very, very common. And you know, strike slip faulting, here the blocks of the crust actually slid horizontally past each other along a vertical or a near vertical fault plane. Okay, there was a fault plane like this, and two plates actually moved like this. So this is what it is saying. And here this particular Sagaing fault extends over 1200 kilometers throughout the length of Myanmar, roughly north-south. And next it is a transform boundary. We all know, right? It is a transform boundary. It is a transform boundary between the Indian plate as well as the Sunda microplate. Sunda microplate is nothing but it's a part of the Eurasian plate which is actually moving more slowly. Okay, so this is what it is. Now let us actually move and see this kind of faulting, right? This actually happens, or it leads to shallow focus earthquakes. We saw, right? What do you mean by shallow focus earthquakes? Shallow focus earthquakes is when the focus is shallow, then the destruction cost is over a larger area. So this kind of transform faulting, or the strike slip faulting leads to shallow focus earthquakes which can cause more surface damage. And also the earthquake was followed by 6.4 magnitude aftershock. Not that important. Okay, so here if you see, this is the Indian plate, and here if you see, this is actually the Eurasian plate, and this is actually the central Myanmar basin. And here you have the Indo-Myanmar ranges and everything. This is you have the Pegu Yoma and the Arakan Yoma, and you can actually see the movement like this. Okay, so this is nothing but it is a transform movement. Okay, so this is actually done here. Now let's move forward. So there have been historically recorded earthquakes in Myanmar around this particular region, around the Sagaing fault. Okay, so it has happened in 1839 also, where the magnitude was around 7.5, and there were number of instances in 1931, in 1946, 56, 1991, and lately This is 2025, around 7.7, where it is near the Saging, which is the highest magnitude in the recent memory. Okay, so all this is not important, but you need to know why this particular region is subjected to a lot of shallow focus earthquakes that we have discussed in this particular article. Now, let's move forward. The last article for discussion is Center has recently signed around 62,000 crore of deal with Hindustan Aeronautics Limited in order to get the indigenous light combat helicopters. Okay, so here what is important to understand, what do you mean by light combat indigenous helicopters, and what is the objective beyond going indigenous. Okay, so we have Make in India, okay, or Atmanirbhar, where we have to have a self-sufficient India, right? So this is what it is, and this is important for both the prelims examination as well as mains GS paper 2, bilateral, regional and global groupings and agreements involving India. I think this is not a part of it. So this is GS paper 3. It can come under security. It is given by mistake, okay? So it is given under security. Now let us move forward. Excuse me. Yeah, in the previous year, in 2018, we had a question on THAAD, that is Terminal High Altitude Area Defense System. Okay, sometimes seen in news, whether it is an radar system or whether it is a defense collaboration between any of the two countries. So this becomes again very important point of discussion. So let us see. Recently, the Defense Ministry has signed a deal with HAL, that is Hindustan Aeronautics Limited, in order to acquire around 156 indigenous light combat helicopters. Okay, so what are these light combat helicopters? These are very capable of high altitude combat capability. Combat means in order to strike the enemies. Okay, so they can actually perform even at an altitude which is as high as the Siachen glacier. Okay, Siachen. So in the Siachen area also it can be used, and this objective was to build a self-reliant India in defense with over using 65% of the indigenous content, okay, and involvement of over 250 plus domestic firms, okay, thereby giving a boost to the manufacturing sector also with reference to defense. Now, what do you mean by the indigenous light combat helicopters? The what to say, the importance of light combat helicopters was actually realized after the Kargil conflict of 1999. Okay, so first indigenously designed and developed combat helicopter was actually introduced or formally inducted after the 1999 Kargil war, where the high altitude operational needs were actually there. Okay, so this again was developed by HAL. Then it got formally inducted into the Indian Air Force, where it is actually used in operations in high altitude zones also, like the Siachen. Why? Because it has a high altitude capability. That is, it is the only attack helicopter in the world which is capable of landing and taking off at 5,000 meters, and it also has a significant payload. That is, it can carry both the weapons as well as fuel at large quantities. Next one, if you see the performance parameters, of course, it actually, the takeoff weight is around 5.8 tons. The maximum speed with which it can operate is around 268 km per hour. The range is 550 kilometers, and the endurance of it actually exceeds beyond 3 hours. Okay, and the service ceiling is around 6.5 kilometers, and the combat radius is around 500 kilometers. So these are specifications of the indigenous light combat helicopter. Okay, moving forward, let us actually see. This is actually the image of the light combat helicopter. Okay, so this is what is the image all about. Now, moving forward, it also has other features like the survivability features. That is, it has the crash proof structure and it has a landing gear. And the materials are radar absorbing also, and it also reduces the radar signature. It has a pressurized cabin, and this is for protection against any kind of nuclear or biological or any kind of chemical threats, that is the NBC threats. And it is also equipped with the self-protecting systems, okay, where it has countermeasure dispensing system in order to shield against the enemy radars as well as any kind of other guided missiles. Okay. Now, the weapon system, it is actually armed with a turret gun, that is 20 turret gun, and it has rockets, and then you have Mistral 2 air-to-air missiles and all these anti-tank guided missiles. Okay, and here, as we know, we are actually aiming to have around 65% of indigenous content. This is actually targeted in order to boost the MSMEs, and this is expected to generate around 8,500 plus direct as well as indirect jobs. Okay, and it is also of a strategic significance because India actually aims at Atmanirbhar Bharat, where we aim at self-reliance India. Okay, and also it ensures or enhances the combat readiness even in the mountain terrain as well as the high altitude regions. Okay, so this is what this article is talking about. Now, let's quickly solve the mains practice question. So, discuss the various dimensions of the right to freedom of speech and expression under the Indian Constitution and substantiate your answer with relevant case laws. So, this particular question can be targeted or it can be approached by having the introduction, the body and the conclusion. In the introduction, we will talk about the right to freedom of speech and expression, which is enshrined under Article 19, Clause 1, Clause A of the Constitution, how it is fundamental, okay, in the democratic society, how it empowers, okay, an individual in order to voice out their opinion, in order to access the information freely, etc. Okay. However, it is not absolute. It is subjected to reasonable restrictions under Article 19, Clause 1, Clause 2. So, this is your introduction, and in the body we will talk about the dimensions of right to freedom of speech and expression. That is, first is what is freedom of press and what did the Supreme Court had to say. Next one, the right to information. Next one, the right to be silent and what again the Supreme Court had to say in different forms of judgment. So these are the dimensions that you have to discuss in the body, and also the right to broadcast, example, in the Doordarshan, and then right to criticize as well as provide the dissent and freedom, whether it actually includes the hate speech or not. All these you need to discuss in your answer. Okay. Now, moving forward, you need to conclude the answer. It has to be a very, very balanced approach where you say the freedom of speech and expression is cornerstone of a democracy. While the courts have broadly interpreted, they have also updated the reasonable restrictions under Article 19 Clause 2 in order to prevent the abuse. And balancing liberty with responsibility is essential in order to preserve both the individual rights as well as the public order. So, both have to go hand in hand is what this article is saying. Now, moving forward, let us solve the MCQs that were part of yesterday's discussion of the DNA. So, consider the following defense related agreements and initiatives between India and the United States. Defense Technology and Trade Initiative. This is not a part of India and US relations. Then the LEMOA, that is the Logistic Exchange Memorandum of Agreement. Then the COMCASA, that is Communications Compatibility and Security Agreement, as well as the BECA, that is the Basic Exchange and Cooperation Agreement. So all these are part of India and US defense ties, and the first one is not. So 2, 3 and 4. So here B will be your answer. So again, read about these in detail, okay, because questions can come from any dimension. Next one, with reference to the military exercise, consider the following. So, exercise Prachand Prahar was conducted by India in collaboration with that of foreign armed forces. No, it is actually an internal exercise that was conducted by India. So, this is wrong. So, it is a tri-service exercise conducted in a digitally contested environment simulating future warfare. Correct. The next one, the exercise was held in desert terrain of Rajasthan under Southern Command. No, it actually took place in Arunachal Pradesh, right? So, this is also wrong. So, the first one is wrong, the third one is wrong. So, only 2 is correct. So, again, your answer is going to be option B. Now, let us solve the next MCQ. With reference to the legal and the institutional framework for women's safety in India, consider the following. So, the protection of women from Domestic Violence Act of 2005 provides for appointment of protection officers and support services like shelter and medical aid. Yes, correct. The next one, the Criminal Law Amendment Act introduced the death penalty for rape of a girl child below the age of 18 years. No, it's 12 years, so this is wrong. The Vishaka guidelines had laid down by the Supreme Court later became the basis for the enactment of the POSH Act. Yes, correct. So the Ujjwala scheme is aimed at promoting girl child education in rural areas. No, this is wrong. Okay, this is also to protect the women against harassment and abuse, domestic violence, etc. So 1 is correct and 3 is correct, right? So 1 and 3, A. So the answer will be A. Okay. So next we will actually see the list of questions that are the result of today's discussion. One is on the light combat helicopter and how much of engine it is powered with, what is the payload capacity, the flight capacity, maneuverability, etc. The next one is consider the following statements. The Contempt of the Courts Act, it was under which committee? Then the Constitution of India empowers the Supreme Court and the High Court to punish the people who are doing it, for the contempt of themselves. Yes. Then Parliament is vested with the powers or not, whether Parliament can do it or the court itself will come up with the process that you need to know. Next, last question, the context of the plate tectonics, which of the following best describes a strike slip fault? We actually saw, right, different types of faults, the normal, the reverse, the thrust, as well as the strike slip fault. So you need to know whether it is a transform fault or whether it is because of the divergent or the convergent boundaries. So I actually request you to solve all these questions on our website, the link of which is given below in the comment section, in order to know where you stand with respect to today's lecture. Okay, so from here we've actually come up we have actually come to the end of our DNA discussion. So for further such videos as well as live interactive sessions, please do like, share and subscribe to Narayana IAS Academy YouTube channel. Thank you, and we'll meet again with yet another live session.